Hi, welcome to our channel of IGNOU audiobooks, Indira Gandhi National Open University, School of Law, SOL, Diploma, Postgraduate Diploma in Intellectual Property Rights, PGDIPR, MIP 101 General Introductions to IP Rights. Block-1 Concept of Property, Unit 1 Concept of Property. 1.1 Introduction. Property is physical or intangible entity that is owned by a person or jointly by a group of persons or a legal entity. The owner of the property can, based on the nature of property, consume, sell, rent, mortgage, transfer, exchange or destroy it, or as per his choice exclude others from doing these things. We commonly recognize various types of property such as real property, personal property, private property, public property and intellectual property. Property has been defined by different people in different ways, but it is evident that all of them treat property as a means and not as an end. So, one can agree that property is a means to lead a good life. Most of the times property is defined as a fragment, i.e. a relationship people with respect to a thing, or only as a right, or sometimes a combination of both, and this is so because people fail to understand the complex relationship between the two. Different disciplines, such as law, economics or sociology, treat property in different manner. However, they treat property in a very systematic manner. The definitions given by these disciplines too vary. 1.20 BJECTIVES. After reading this unit, you should be able to define what property is, explain the distinction between property and intellectual property, and discuss the concept of property. 1.20 BJECTIVES. After reading this unit, you should be able to define what property is, explain the distinction between property and intellectual property, and discuss the concept of property. 4. Public property, or collective property, refers to property owned by state or community or government. This property is dedicated to the use of the public. Example: public parks, roads, public transport, buses, trains, etc. 5. Intellectual property refers to exclusive rights over artistic and other creations of mind, inventions. This is also known as intangible property. Example: patents, designs, trademarks, copyrights, etc. 1.3.1 Ownerless things. Ideas. Normally ideas cannot be the property of any one person, as two persons can have the same idea. Seawater. Seawater cannot be the property of anyone. However, on the basis of territorial jurisdiction, any one nation can claim that the seawater in its territory belongs to that nation. Celestial bodies. Similarly, celestial bodies in the space are ownerless things, and thus not the property of anyone. 1.3.2 What can be property? Effort with an object. According to John Locke, effort are necessary to create a property. Example: mixing your labor with an object, or clearing and cultivating virgin land. Intellectual property. Possession and ownership. It was a notion earlier that any person who owned anything first became the owner of that thing. This applied mainly on chattels as well as land. So, one can say that the idea of possession came prior to ownership. Scarcity of objects. According to Benjamin Tucker, the purpose of property is to solve the scarcity problem. He suggested that only when things are relatively scarce with respect to people's desires do they become property. E.g., agriculture. Land and houses built on land. 1.4 General characteristics of property. Right. Traditionally following principles are attributed to existence of a property rights. 1. Control of the use of the property. 2. The right to any benefit from the property. Examples: mining rights and rent. 3. The right to transfer or sell the property. 4. The right to exclude others from the property. Traditional property rights, however, exclude uses of property that unreasonably interfere with 1. The property rights of another private party, the right of quiet enjoyment. 2. The public property rights, including uses that interfere with public health, safety, peace or convenience. 1.5 Attributes of property. Oliver Wendell Holmes describes property as having two fundamental attributes, i.e., possession and title. 1.5.1 Possession. Possession is defined as control over a resource based on the practical inability of another to contradict the ends of the possessor. 1.5.2 Title. Title is defined as the expectation that others will recognize rights to control resource, even when it is not in possession. Possession is defined as control over a resource based on the practical inability of another to contradict the ends of the possessor. Possession has been defined by various writers in a different ways. According to Holmes, to gain possession a man must stand in a certain physical relation to the object and to the rest of the world and must have certain intent. Salmon divides possession into incorporeal and corporeal and defines corporeal possession as the continuing exercise of a claim. There are two elements, the corpus and animus. According to Pollock, in common speech a man is said to possess or to be in possession of anything of which he has the apparent control or from the use of which he has the apparent power of excluding others. The above definition emphasizes more on the intent or animus. The intent that constitutes possession is the intent to exclude others. In English law, the intent or the animus is the main element of possession. However, it also requires some kind of physical relationship with the object. As it is understood, possession has two elements. Corpus. Corpus means that there exists such physical contact of a person with a thing as to give rise to a reasonable assumption that others will not interfere with it. Corpus depends upon the nature of the thing. Thus, whether in a particular case the necessary physical relation exists or not depends among other things upon the nature of the thing also. The contract or relation has two aspects. 1. The relation of the possession to other persons, and 2. The relation of the possession to the thing possessed. 1. The relation of the possession to other person. According to Salmond, a person is in possession of a thing if it create a reasonable expectations that he will not be interfered by anyone in the use of it. 2. The relation of the possessor to the thing possessed. Salmond says that the necessary relation between the possessor and thing possessed is such as to admit of his making such use of it as accords with the nature of the thing and of his claim to it. Both of the above aspects are necessary to constitute possessions. By possession means the person has the apparent control. Any domestic animal that is in the habit of returning home shall be considered in the possession of the master although he is wandering during the day. In Ancora v. Rogers, A was permitted to put her goods in a room in B's house. A sent the goods, though a man who kept it in the allotted room and locked it and took away the key with him. A was held to be in possession of the room. Animus. The corpus, the physical control, alone cannot constitute the possession. Animus is a lot necessary. It means that there must be an intent or mental consciousness on the part of the possessor to exclude any interference by others. The important things about animus are: A. The person having the animus is not necessarily the owner and he is also aware of it. For ego, a tenant and a mortgagee are not owners and they know it. B. The animus is not necessarily based on a possessor's own interest or right. As in the case of Bailey, he has the possession of the object hailed although the animus to exclude others is not on his own behalf. C. It is not necessary that the animus should be specific, it may be a general animus. D. It is not necessary that the animus should be based on a legal claim to the object. A. The animus must be of exclusive claim to the object. 1.5.3 Cases on possession. In Mary v. Green 1841, 7 M&W. 623, a person purchased a bureau. He found some money in a drawer which he appropriated. He was corrected for larceny, F, on the principle that the money was not in his possession until he found it. Here animus was lacking. In another case, in R. V. Moore, 1861, L&C. In this case a bank note was dropped in the shop of the accused. The accused found it and appropriated it knowing full well that the owner could be discovered. He was convicted of larceny. It means that the accused was not in possession until he actually found the bank note because the animus was lacking. In another case, Bridges v. Hawksworth, 1851, 21 LJQ, B. 75. In this case, a pocketbook was left on the floor of the shop of the defendant shopkeeper by a customer. The plaintiff, who was also a customer, found it. He gave it to the defendant by the purpose of returning it to the real owner when he was discovered. It was held that the plaintiff, and not the defendant, first acquired possession of the book, and so it belonged to him in default of the real owner. The defendant did not know of the existence of the hook before the plaintiff found it, therefore the former has no animus and consequently, he was not in possession of it. Possession is said to be 9 points of law. It means that a person in possession of an object has better claim over it against the whole world except the real owner. In the case of Armory vs. Delamance 1 Stra 1722-505, a chimney boy found a jewel and took it to the shop of the defendant to know its value. The defendant refused to return to the boy on the ground that the boy was not the owner. The boy was allowed to recover it from the shopkeeper. The boy, being the prior possessor, had a better claim to it against the whole world except the real owner. And as the shopkeeper's claim was not on behalf of the owner, the claim of the boy prevailed against him. 1.60 WNERSHIP. Ownership is an akin conception of possession. It seems historically that first the concept of possession came into being and then the concept of ownership gradually developed out of it due to changes in the economic structure of the society. The concept of ownership came into being when the society changed from romantic to agricultural. According to Holdouth, English law reached the conception of the ownership as an absolute right, through development in the law of possession. Ownership and property are correlated terms. Ownership has a peculiar kind of relationship between a person and a thing. This relationship can be looked from two different angles. One can look at it from the angle of the person in whom the bundle of rights over the thing vests, which constitutes ownership, or it can be looked at from the angle of the thing and can be studied as subject to a special kind of control exercised by a particular individual. The bundle of rights of a person over a thing give him the ownership of the thing, and the control exercised by the person over the thing makes the thing a property of that person. This the idea behind the ownership and property are. They are fundamentally the same, and the ownership and property are the two aspects of the same relation. These concepts are mutually interdependent and one cannot be fully and clearly understood without the other. The rights of ownership constitute the three important rights, which are: 1. The right of possession of the property owned. 2. The right of enjoyment of the property, which includes in it the power to deal with the property as the owner likes. 3. The right to dispose the property. In India, earlier the right to property was a fundamental right, but later on this right became a legal right. Now right to property in India is a legal right. 1.7 Theories of property. There are a number of theories which define the origin and the justification of property. Some of these theories have been dealt with in this unit. They are: 1. Natural law theory. According to this theory, property is based on the principle of natural reason, derived from the nature of things. This means that whosoever occupies a piece of land and by his toil does something to the land becomes the owner of that property. The advocates of this theory are Grotius, Pufendorf, Locke and Blackstone. Grotius is of the above view that whosoever occupied a property becomes the owner of that property, as he thinks that all things originally do not have any owners, so the one who occupies or captures that property becomes the owner of that thing. Pufendorf is of the view that the property belongs to the people as a whole, and thus there is no concept of individual ownership. He is of the view that the concept of private ownership is the result of a pact or a private agreement. Again, Blackstone is of the view that the one who possesses a piece of property continues to be the owner of the property as long as he uses that property. So in case he continues using it for perpetuity, he will be the owner forever. Thus one can say that the natural theory was of the view that whosoever possesses a property becomes the owner of that property as long as he uses it. 2. The metaphysical theory. Kant and Hegel were the propounders of this theory. According to them, a property is mine if I am so connected with it that if somebody uses it against my will or direction causes the act of injury to me. According to Kant, property is a part of the human personality, and so its existence and protection is necessary. This theory was criticized as it was not much concerned with the realities but based on metaphysical notions. But the fact is that a person dependent on the property of another does not live a free life. 3. Historical theory. As per this theory, the institution of private property has developed through a steady growth. The idea of individual property has been developed out of group or collective property. It said that the various stages involved in the growth of individual property were firstly that of the natural possession which existed independently of the law or the state. The second stage was that of the juristic possession, which was a conception both of law and fact, and finally the stage of ownership, which is purely a legal conception whose origin lies in law alone. Thus, it says that owner here is provided with the exclusive control and enjoyment of the thing owned by him. This theory mainly focuses on the view that property never belonged to any individual but to larger societies which were composed on the patriarchal mode. Dean Roscoe Pound was of the view that the earliest form of property was that of the group property, which was later on disintegrated by larger families, this constituting into individual properties. 4. Psychological theory. This theory is of the view that the natural instinct of man to acquire and control things and objects results in the acquisition of property. Thus the law confers certain rights on the individuals with respect to the object which he has acquired. According to Jeremy Bentham, property is nothing more than the basis of certain expectation of deriving hereafter certain advantages from a thing by reason of the relation in which we stand towards it. 1.8 Definition of property, by different philosophers. Thomas Hobbes, 17th century. According to Thomas Hobbes' idea of property was of giving to every man his own. This was a phrase which he drew from the writings of Cicero. However, he could not understand how could anyone say anything to be his own, and so he said that anything can be my own if the thing was truly mine, added if there was any strong power which was ambiguous in the realm and that power treated that thing to be mine and also protected its status as such. James Harrington, 17th century. James Harrington was a contemporary of Hobbes, however his definition of property was different. According to him, property was a natural phenomenon. He said that property, in spite of being natural, was not inevitable. He thought political power was there as a consequence and not because of the distribution of property. He said that the worst possible situation is when the masses possess half of the nation's property and the other half is being owned by the crown. This was a situation of instability and violence, and therefore the best situation will be then when the masses will acquire most of the property. In the later years, Harrington's admirers included American revolutionary and founder John Adams, Sir Robert Filmer. According to him, property rights are similar to household goods, that a father may distribute among his children which he could take back and dispose of according to his pleasure. John Locke. According to Locke, every man has a property in his own person. Every individual has a right to preserve his property, that is his wife, liberty and estate. William Blackstone. According to him, the inferior hath no kind of property in the company, care or assistance of the superior, as the superior is held to have in those of the inferior. 1.9 Meaning of property. Speaking broadly, property includes all the legal rights of a person, irrespective of its description. Accordingly, the property of a man is that which the law provides him. Talking narrowly about the property, those include a person's proprietary rights and not his personal rights. That means property includes only those rights of a person which he owes in his property and not his personal rights, which is associated with his status or personal condition. Thus, we can say that a property of a person may include those, for example, his land, his chattel, shares, debts which are due to him and not his life or his liberty or his reputation. In other sense, the term property means those rights which are both his proprietary as well as real. This sense includes a patent, a copyright, a free hold, a leasehold estate. All of these are property of a person. However, they do not include a debt or the benefit of a contract. In a very narrowest sense, property may mean corporal property or right of ownership in anything which may be material. In this context, according to Ahrens, property is a material object subject to the immediate power of a person. According to Austin, the term property is used as the greatest right of enjoyment according to law and which excludes servitudes. In this manner, life interests are considered as property. Servitudes are also considered as property, however they require a legal title. Thus a property includes the complete asset of a man, which is rights in rem and rights in personam. 1.10 Property in common law. The common law has a very distinct approach towards property. According to common law, possession, or occupancy, is the origin of property. Thus the possessor of an animal who finds it will own the animal. If I find a treasure which is buried in my land, I will possess it, because occupancy the place in which it is buried and I am in possession of the land. The case of Pearson v. Post 3 Chi R. 175, NY. Sup. Ct. 1805, is a very historical one of the 19th century. In this case, post a person was hunting the fox one day on an abandoned beach and he almost has aimed on the fox when an interloper appeared of nowhere and killed the fox and ran away with concern. Post thus sued the interloper for the value of the fox on the basis of this theory, alleging that his pursuit of the fox had established his property right to it. The court, however, disagreed. It cited a long list of learned authorities. 1.11 Property in business law. It is rightly said that business law would not exist if a thing like property would not exist. Thus, concept of property has great importance in terms of business law. When one speaks about property for a layman, it means personal property, such as an almirah or a chair or refrigerator, or an immovable asset, such as real property, i.e., his home, his fiat, a building, etc. This refers to tangible property. But when speaks legally, the term property refers neither to objects nor to land alone. So in its legal sense, it means or it refers to those rights that are legally protected to use, possess, enjoy or to dispose it. Land and other physical objects can exist where there is no law, for example, rocks on the moon. However, property rights can exist where there is some law to define and enforce them. Law protects people in the exercise of property rights. Thus law contributes to the value of things. 1.12 Supreme Court's view. In R.A. Cooper v. Union of India, Air 1970, South Carolina 564, the definition of property has been quoted as, property means the highest right a man can have to anything, the right being the one which has lands or tenements, goods or chattels which does not depend on others' courtesy. It includes ownership, estates and interest in corporeal things, and also rights such as trademarks, copyrights, patents and even rights in personam capable of transfer or transmission, such as debts, and signifies a beneficial right to or a thing considered as having a money value, especially with reference to transfer or succession, and of their capacity of being injured. 1.13 Intellectual property rights. In recent times, intellectual property is gaining importance in trademarks, property in designs and patents. Earl J. in Jeffries v. Boosie 4H. L. C. 815, 869, 1854, observed that, the notion of Mr. Justice Yates that nothing is property which cannot be earmarked and recovered in detenu or trover, may be hue in an early stage of society when property is in its simplest form and the remedies for violation of it are also simple, but it is not true in a more civilized state when the relations of life and the interests arising therefrom are complicated. Intellectual property rights are granted to a company or a person by a state for the products of intellectual effort and ingenuity. The basic concept of intellectual property can be related to the 4th century BC. A person is rewarded for its innovation because the idea of that innovation belongs to the one who has created it. In other words, an idea is the manifestation of the creator personality, and thus whatever labor he has spent in creating it should be rewarded with something, i.e., property. In today's scenario, which is completely market-based, the idea of protecting intellectual property is essentially utilitarian. If new knowledge is made accessible to all freely, then the person who invents it will be at a loss, as he will not be provided with any incentive it may lead him of not producing any new idea anymore. However, with the help of new knowledge, maximum benefit can be provided to the maximum people by the utilization of these ideas. Therefore, there is a need to reward those who had invented that idea, thus giving them an incentive to create more new ideas to benefit the maximum, as these ideas can be used for benefiting the masses. 1.14 Illustration of IPR. Rahim writes a book. The manuscript of the book is Rahim property. The book is published and one of the copy of the book is purchased by Sheila. Thus Sheila owns the book and the book is her property. However, Rahim is the author of the book and has the right to copy and distribute the book. Rahim as the author also has property rights to restrict anyone from using any other person in any manner who owns a copy of it. For e.g., it is illegal to sell photocopies of a copyrighted book without the copywriter's permission. Now, Rahim can transform the manuscript of the book in a movie also. These rights are form of property that is separate from the book. In fact, these rights may be bought and sold separately. Therefore, rights attached to property may change from person to person and from time to time. Thus, we can say that the idea of a property is a part and parcel of a standard society in this modern age. 1.15 SUMMARY. Property is any physical or intangible entity that is owned by a person or jointly by a group of a people. Property is a means to lead a good life. Property includes all the legal rights of a person irrespective of its description. Concept of property has great importance in terms of business law. IP rights include copyrights, trademarks, property in design and patents. Thank you. Subscribe to our channel for more updates, and we will see you with the next chapter.